Welcome back to Court TV Live. I'm Judge Ashley Wilcott here with Michael Ayala. We expect opening statements tomorrow in the Kentucky trial for defendant Bradley Caraway. The 41-year-old stands accused of driving drunk and crashing his car on a freeway. This was back in 2016. There was a passenger, Shanae Moorman, a former college cheerleader who was ejected from the vehicle and eventually succumbed to her injuries.
Caraway has now been charged with murder and leaving the scene of an accident. His case did go to trial before, but a judge declared a mistrial last summer after Caraway's attorney became sick and could not continue. Court TV's very own Matt Johnson has a closer look at this tragic case.
Bradley Caraway crashed on a ramp off an interstate in Louisville, Kentucky in the early morning hours of August 6, 2016. His car overturned, causing his passenger, Shanae Moorman, to be ejected. She was trapped under the vehicle and had to be extracted by first responders. She was pronounced dead at the scene. Caraway was not in the car when police arrived and was arrested several hours later, walking along the ramp off Interstate 265. According to the incident report, officers at the scene observed Bradley Caraway was wearing no shirt or shoes and had injuries that were consistent with being in a motor vehicle collision. The officers also noted that Caraway smelled strongly of alcohol and appeared intoxicated. He was subsequently charged with murder, leaving the scene of an accident, driving while intoxicated, and failure to maintain the required insurance. It's been 7 years since Caraway allegedly walked away from the accident and Shanae Moorman.
Very unfortunate. That's what a Louisville judge had to say today about a 7-year delay in the murder trial of a former U of L cheerleader.
Caraway has pleaded not guilty and maintains his innocence. His criminal trial has been fraught with delays. Last year, a mistrial was declared after his lawyer became ill and could not continue. The setbacks have been frustrating for Moorman's family and friends.
There's no closure. We have to walk in the courtroom and see him. 7 years. His family gets to walk out with him. We don't get that. She's missed so many important milestones.
All right, still with us, Nima Rahmani. Nima, you know, he's found walking down the road. She's trapped under that car. Arguably, if he had helped her, she may not have died. Does it hold water, a defense of it wasn't me, I wasn't driving?
Doesn't hold a lot of water. So usually there's not a duty to render aid, but when you injure someone or put them in peril, that duty does apply. We all know that fleeing the scene, any type of flight, that's consciousness of guilt. So, you know, you have someone who's under the influence. Maybe this could have been a vehicular manslaughter case, but all of a sudden you leave someone to die, you flee, you know, you do those types of things. That's where you start getting from that criminal negligence to that intent and how you end up getting charged with murder.
Yeah, Nima, I was going to say, I don't want to say it's a far leap to go from, you know, the vehicular manslaughter to the murder. And just leaving the scene in this case, I would wonder, as a defense attorney, you know, there's a lot going on. The guy had glass in his head. There was his DNA found on the windshield. Clearly, there was a very serious head knock here. He had just been in a very serious accident that killed someone else in the car. How do they show that he was cognizant enough to know that, first of all, what actually just happened, and that he would have made choices that led to her death?
Michael, I agree. So when you're defending cases, the two broad categories of defenses are it wasn't me and I didn't mean to do it. You know, we talked about the it wasn't me. Ashley raised that. I think it's going to be very tough to argue that it wasn't him. I mean, that's sort of the home run. I think you start to go down that intent, that knowledge route. You know, you start to challenge, you know, did he really intend to commit murder? Was there that legal duty? This is where you get into some of those legal arguments, right? You know, if someone puts someone in peril, they don't provide aid, is that really malice? Does that rise to that level of knowledge and intent? Or is this someone that just acted negligently after the scene? So, you know, when you're analyzing that criminal negligence, there's two different phases. So the first phase, when you drink and you get behind the wheel of a car. Voluntary intoxication, not a defense generally. So that's not going to work. But it can reduce that mens rea, that criminal intent, right? We talked about first-degree murder, lying awake. This is certainly not that. Maybe it can even reduce that second-degree murder down to that involuntary manslaughter. And then, of course, are his actions after the scene. You know, if, you know, you can attack the causation and say, well, listen, she died on impact. Even if he had called 911, he hadn't left. Maybe she would still be alive. Not saying that's the case, but I'm sure the defense will put on experts to say that. And then, like you said, attack, you know, say, listen, here's someone who suffered a head injury, didn't know what he was doing, wasn't intending to kill or, you know, inflict serious bodily injury. So therefore, manslaughter charges are appropriate here. So I think mitigation is the way to go for the defense.
Yeah, mitigation is the way. And you know what's interesting? This case, Judge and Nima, is going to end up being really a battle of the experts. Because number one, we talk about the death of the victim in this case. According to the medical examiner, positional asphyxia was the cause of death, and that if they say if he would have helped her, she would have survived. So the defense is attacking that conclusion. How do they know that perhaps she would have survived if he helped her or pulled her out from under the car? And also, in terms of whether he was driving, I think this is fascinating. They got some crime scene reconstruction, and apparently there were signs that the seat was so far back on the driver's side that the 5'2" victim could not have driven, could not have touched the pedals. There was soil on the pedal that matched soil on his shoes. So they're going to bring in all these experts to testify to this stuff. Could be really interesting.
It's hard for me to imagine how a jury won't find that he was driving based on that evidence if they present it all. Because the other thing I'm going to suggest is, you're right, intoxication, voluntary intoxication is not a defense. However, I wonder, does he even remember what happened? Does he even remember he was driving, depending on the level of intoxication? And that's not a defense, but it is why I wonder if a jury's going to downgrade from the murder charge, but we'll have to wait and see.